Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court this morning because you have a case in this court. Now, today, your case is set for what we call an arraignment. And what the arraignment is an opportunity to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are your more serious type of offenses, whereas your misdemeanor cases are referred to as your petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony offense. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. If a person is convicted of a state jail felony, the range of punishment is a minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment, if they are convicted, is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, your case is a misdemeanor case, so you don't have to worry about those type of punishments. Now, misdemeanor cases are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is a fine only, and the fine cannot go above or exceed $500. Class C misdemeanors are traffic offense, like not wearing your seatbelt, speeding, those type of offenses. In those cases, start in the JP court or the city court, and then they come to this court when a person appealed the case. They found guilty there, they want an appeal, they get a whole new trial, he comes here. The range of punishment is still the same, it does not change, which means that you only can get a fine up to $500 or less. All right. Now, if you fail to pay the fine, or if your fine was converted to community service and you failed to perform the community service, then the court can issue what is called a capias pro fine. And what that means is a warrant for your arrest to either pay the fine or sit out the time in jail. And you get $100 credit for every day that you sit out in the jail to pay off your fine. Okay. Now, the next highest misdemeanor is a Class B misdemeanor. With the Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days, which is 6 months in the county jail, or you could be given a fine that does not exceed or go above $2,000, or you could be given both such fine and jail time. Now, the highest misdemeanor is a Class A misdemeanor. The range of punishment for a Class A misdemeanor is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or a fine that does not exceed $4,000, or you could be given both such jail time and a fine. Now, you may be eligible for probation. There are two types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation. We normally refer to it as deferred probation. What that basically means is if you get on that type of probation, unadjudicated probation, you don't have a conviction on your record. And if you successfully complete the probation, then the case will be dismissed. It will not result in a conviction on your record, and you may qualify for non-disclosure. Non-disclosure will be where your record is sealed to the general public. Okay? Now, the operative word that I use is general public. That means that the general public cannot have access, but the government can. And there are a list of government agencies in the Texas Code of Criminal Procedure that can have access. But most of the public is the general public, so they cannot have access if you get a non-disclosure. Now, the next type of probation is called adjudicated probation. You had unadjudicated probation, and now we have adjudicated probation. With adjudicated probation, we normally refer to that as regular probation. With the adjudicated probation, it does result in a conviction on your record once you get on it. However, there's something that is called judicial clemency, whereby the judge set aside that conviction, and you no longer have a conviction on your record. And the way it works is you have to first successfully complete the probation. There cannot be any more time left on the probation, and the probation department have to give you what is called a discharge. Okay, if those three things happen, then the court has the discretion to give you judicial clemency, and so you won't have a conviction on the record. However, if you get another conviction later on, then the case that you received judicial clemency on can be brought back up, it can be resurrected, it can be used against you. And if you try to get a license with CPS, which is Child Protective Services, they can deny giving you a license, or if you have a license, they can revoke or suspend the license. Okay. Now, as a defendant in a criminal case, you have rights. Okay. And we're going to talk about some of those rights that you have. The first right that I wanted to talk about is your right to have an attorney. That clipboard that you have, make sure everyone that's here for a case have a clipboard. I'm going to go over that document. That first document behind that little page is titled Judge's Explanation of Defendant's Rights. Okay, judge's explanation of judge's explanation of rights to defendants without an attorney. Okay, now this document states that as a defendant in a criminal case, you have three options. And it says here, three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. Now, the first paragraph under number three says that if you want an attorney, you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date to give you time to hire an attorney. And the second paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to you by the court. But you must first fill out a financial questionnaire. Now, the financial questionnaire is a 3-page document that is also on the clipboard. It looks like this. It says, Jefferson County Affidavit of Indigence. Now, this is only for people who will be applying for a court-appointed attorney. If you want a court-appointed attorney, you will fill out the first page of this document, okay? The first page of this document, and then you go to the second page, and at the second page, on the second page rather, at the top, it says defendant's oath. You'll fill out this section. Basically, it's your name and the date. And then you go to the middle portion that says unsworn declaration by defendant. You fill out and then you'll stop. Okay? And I'm gonna give you time to do that. Okay, now let's turn back to the first document, judge's explanation of rights to defendants without attorney. And on that document, the next paragraph states that you may not speak to the prosecutor unless you first sign a written waiver of your right to attorney. And this is for individuals who would like to represent themselves. If you like to represent yourself, that means that you'll be your own attorney. You'll have an opportunity to talk to one of the two prosecutors. Prosecutors are assistant criminal district attorneys that works for the Jefferson County DA's office. You can talk to them about your case to see if y'all can work out a settlement. We call that a plea bargain. Now, you cannot talk to them unless you first sign a waiver. The waiver is you waiving your right to have an attorney. The waiver is another document on that clipboard that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. That's only for people who will be representing themselves. If you're not representing this, if you don't want to represent yourself, you don't need to worry about that document. Okay? Now, those individuals who like to represent themselves have an opportunity to talk to the prosecutor. You'll fill out, read the document that says titled Waiver of Counsel, and that document looks like this. If anybody is going to be waiving their right to an attorney, you read this and sign the date, and then you'll stop. Okay. Now, going back to the first document. Now, everybody is going to make a choice on this document. Okay, everybody's here. Everybody's here. Now, there's a paragraph in block form right here on this document. That's for individuals who like to represent themselves and say you should be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in the worst outcome for you and your case, including the loss of significant rights and opportunities related to military service, housing and public benefits, child custody, immigration status for non-citizens, employment, and possession of a firearm. Okay? Those are some of the things that you should be aware of. Now, if you decide that you would like to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. So, for example, let's say you said, okay, I'm going to represent myself and I'm going to talk to the prosecutors. And prosecutors has made an offer to settle the case, but I don't like it. Okay, let's say you wanted to get probation or time served for the time that you already spent in jail, and they're offering more time. You know, you served 5 days, they want you to serve 10 days, and you say, I don't want that. And you say, well, I want a lawyer. You have a right to change your mind. Okay? And request that a lawyer be appointed to represent. Now, at the bottom of this document, this is where I say everybody's going to make a choice. At the bottom of this document, in bold letters, it says defendant's choice. And it states that mark initials next to only one choice. Now, if you would like to hire your own attorney, then you're going to place your initials on the first line to the left. If you want to hire an attorney, put your initials on the first line to the left, sign and date it, and then you stop, and that's the only document. This is the only document you have to fill out. All right. Now, if you would like to, if you already have an attorney, then you'll put your initials on the second line to the left, the name of the attorney on the line to the right, then you'll sign, date it, and stop. Now, if you would like to apply for a court-appointed attorney, then you'll put your initials on the third line to the left. At the bottom, put your initials on the third line to the left. You'll sign, dated today's date, July 1st, and then you will fill out this document, Jefferson County Affidavit of Indigence. First page, like I said, and then you go to the second page, you're gonna fill out the top portion, says defendant's oath and unsworn declaration, then you stop. Okay. Now, if you would like to represent yourself, then you will sign or put your initials, on the fifth line to the left down here. If you're gonna represent yourself, you're gonna sign and date it, and then you will fill this document out. It's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. So everybody's gonna make a choice, okay? And we're gonna give you time to do that. Now, just as a quick recap, if you are hired attorney, this is the only document you're gonna sign. We're gonna place your initials on the first line, sign and date. That's it. Okay? For individuals who would like to apply for a court-appointed attorney, you'll put your initials on the third line, sign and date it, and then you're gonna fill out the first page of the affidavit of indigence, and then the top portion says defendant's oath, and then where it says unsworn declaration, you fill that out right here, this section right, and stop. All right, if you would like to represent yourself, then you place your initials on the fifth line to the left, sign and date it, and then you'll read the waiver of counsel for purposes of interviews, please sign and date it, and that's it, okay? Do we have any questions before we go on? Okay. And if you need any help with the paperwork, once I finish, we'll be able to have people to assist you, including myself, to assist you with filling out the paper. Okay? Now, as a defendant in a criminal case, you also have a right to have for example, you're going to enter one of three types of pleas. When I say pleas, this is what I'm talking about. You can enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you have been charged with. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you will not be fighting or you will not be contesting the charges. All right. Now, if you enter a plea of not guilty, you have a right to have a trial by jury. Okay, well, those young men are sitting, we call that the jury box. 6 citizens from Jefferson County will be selected as jurors in your case. They will listen to all of the evidence, listen to the arguments of the lawyers, and then they will go into the jury room and deliberate, and then they will decide to find you either not guilty or guilty of your charges. Now, you can waive, which means to give up. You can waive your right to have an attorney, or give up your right to have an attorney. Your right to have a jury trial. If you waive or give up your right to have a jury trial, that simply means that you will not be having a trial by jury. And then your case can come before the judge. You can have a trial by judge. The judge will be the judge and the jury in the case. The judge will listen to the evidence, listen to the arguments of the attorneys, and then the judge will apply the facts to the law and decide whether to find you either not guilty or guilty of your charge. We call that a bench trial. Okay? Trial by judge only is called a bench trial. Now, if you can waive or give up your right to have a bench trial. If you want to enter a plea of guilty or no contest, then your case is gonna come before the judge by way of a plea bargain. There are two types of plea bargain. One type is called an agreed plea bargain. What an agreed plea bargain is this. Let's say you talk to the prosecutor, or your attorney talk to the prosecutor, and they agree to give you probation. And you say, well, I want that. I want probation. So you agree to take it. That comes before the judge. And the judge can do one or two things. The judge can accept or reject your agreement. If the judge rejects your agreement, well, you can say, well, judge, since you rejected my agreement, I take my plea back. I'm not entering a plea of guilty in no contest. I withdraw my plea. You have a right to do that. Now, if the judge follows the plea bargaining agreement, say, okay, I'm gonna give you probation. And if you decide within 30 days that you would like to appeal your case, in essence, you want to have a higher court to look at your case because you think you've been wrongfully convicted or the court committed an error by convicting you, then we call that, then if that's the case, you have to get permission from the judge to appeal your case. Now, if the judge gives you permission to appeal your case will leave this court and it will go to another court. Actually, it'll go to the Ninth Court of Appeals, right above us, okay? And once it goes to the Ninth Court of Appeals, they will review your case to see if you've been wrongfully convicted or this court committed an error by convicting you. They can do one or two things. They can grant or deny your appeal. If they grant your appeal, they can simply find you not guilty, case over. Or they can send the case back down to this court and order this court to give you a whole new trial. Now, if they deny your appeal, okay, you can appeal it to a higher court than the Ninth Court of Appeal. Actually, you can appeal it to the highest criminal court in the state of Texas, which is the Texas Court of Criminal Appeal. You have to file what is called a petition, a pro se petition for discretionary review. I'll explain that to you. Pro se means that you'll be representing yourself, pro se. And you'll be petitioning the Texas Court of Criminal Appeals to review your case, to see whether or not your appeal should have been granted, or whether or not this court committed an error by convicting you. They can do one or two things. They can either grant or deny your petition. If they grant your petition, they can simply find you not guilty, case over. Or they can send your case back to the Court of Appeals with orders, or they can send it back down to this court with orders. All right. Now, if they deny it, then your conviction will stand at that point. Now, the other type of plea, as I mentioned, you have an agreed plea bargain. You have what is called an unagreed plea bargain. What that means is this here. Let's say you're in the state that talk, you wanted probation, and they say, well, I'm gonna give you, we offered 30 days in jail. You say, I don't want that. Okay. But I want the judge to decide what my punishment is gonna be. That's called an unagreed plea bargain. Okay. And then the judge is gonna look at punishment evidence, and then the judge is gonna give you punishment anywhere within that range. If it's a class A misdemeanor, judge can give you anywhere from 0 days, 1 day to 365 days, or a fine up to $4,000, or both such fine and confinement or probation, either deferred probation or unadjudicated probation. All right. Now, as a defendant in a criminal case, you also have a right to have witnesses to come and testify. If you want to have a trial, you have a right to have witnesses. Witnesses testify from that chair that has the microphone in front of it. That's called a witness stand. And what witnesses do, they can testify for you, against you. You can ask them questions. If you have an attorney, your attorney can ask them questions. We call it either direct examination or cross-examination. Now, you can waive or give up your right to have witnesses as well, which means that if you do that, you will not have any witnesses coming to court to testify. It does not mean that the state will not have witnesses, because they will have witnesses coming to testify in your case. Now, you also have what is called a Fifth Amendment right against self-incrimination. That means you have a right not to testify against yourself. You know, a lot of times we watch television and we see people on these shows like Law and Order. The television law, you go up, want to ask them a question, the person says, "I take the fifth." What he's saying, or what they're saying is that I have a right not to say anything according to the Fifth Amendment of the United States Constitution. And so therefore, I'm not saying nothing. Okay? In essence, I'm not going to say anything that's going to incriminate me. So you can have a Fifth Amendment right against self-incrimination. Now, if you exercise your Fifth Amendment right against self-incrimination, the state, the government, the DA's office cannot call you to testify. Okay? They can't call the defendant to the witness stand. They can't do that because you have a Fifth Amendment right against self-incrimination. And if you think about it, you're innocent unless proven guilty. And the state of Texas had the burden to prove that you're guilty beyond a reasonable doubt. You don't have to prove yourself guilty. Okay, so you have a Fifth Amendment right against self-incrimination. All right. Now, you can waive or give up your Fifth Amendment right. Now, if you waive or give it up, that means you will be testifying. All right. Now, you also have a right to have what we call discovery. And what discovery is, you have a right to see the evidence. You have a right to see the state's file, to see the evidence that they'll be using against you, or that they have and will be using against you. Okay? They call that discovery. Now, you have a right to see witness statements, your statements, police reports, lab reports, photos. You have a right to see video recordings, listen to audio recordings. You have a right to see the instruments, documents, whatever they have. You have a right to have access to that. That's called discovery. Now, if you don't want to have access, you can waive or give up your right to have discovery. Now, everyone that's here today for a case, a case was filed on you, was arrested, placed in jail, you're out of jail on bond, you're either out of jail either on a cash bond, which means that you paid the full amount of the bond to get out of jail, or you're out of jail on a what we call a surety bond. And a surety bond is where you pay the bondsman a percentage of the bond to get out of jail. Or you're out of jail on what we call a PR bond or a personal recognizance bond. And that simply means that you didn't have to pay any money to get out of jail. You was just released under your own personal recognizance. Okay? Now, I say that to say this. Every day that you spent in jail, it can be used as credit toward your punishment. So, for example, let's say you spent 5 days in jail. And let's say you and your attorney talk to the DA's office out for 5 days in jail. You accept that? What that basically means is you don't have to serve no more time in jail. Why? Because you'll be given credit for the time that you've already served, 5 days. Now, if they offer 7 days in jail, you serve 5, that means you have to serve 2 days. Because we'll subtract 5 from the 7 and leaves 2. Now, every day that you spent in jail also can be used as credit toward your fine and court costs. So every day that you spend in jail, you receive $100 credit for every day that you spent in jail that can be used towards your fine and court costs. So if you spent 5 days in jail, that's $500. State's offering you fine and court costs of $500. That means you don't have to pay. Why? Because the 5 days you spent in jail has already paid it off. Therefore, you'll be given credit, and so it'll be taxed and retired. Okay? Now, if they're offering $700, you spent 5 days in jail, which is $500, that means you would have to pay $200. Now, you'll be expected to pay the $200 on the day that you take care of your case. However, if you cannot pay it, no problem. Because we could put you on a payment plan. And you could be paid off in small monthly installments until it's paid off. Now, if you cannot pay it off, even if we put you on a payment plan, no problem. Because we can convert your fine and court costs to community service. You'll do community service at a nonprofit organization. For every 1 hour community service that you perform, $12.50 will be credited toward the paying off your fine and court costs. So for example, if you work 8 hours in one day, that's $100. You work 2 days, 8 hours, that's $200 and it's paid off if you owe $200. All right. Now, Jefferson County District Attorney's Office has a program that is called pretrial diversion. Okay? And with pretrial diversion, this for first-time offenders, they will dismiss your case. And you can get it erased or wiped off your record, like it never happened. In order to qualify, it has to be your first time getting into trouble. It cannot be an offense for unlawful carrying a weapon or resisting arrest. And you have to have an attorney to assist with the application process. Get in the program, case dismissed. You can get it once you complete the program. Then you can get it expunged, which means erased, deleted, or wiped off from the record. Okay? In order to qualify, you have to be your first time getting into trouble. The next thing is, if you're a veteran of any one of the branches of the military, they have a program called Veterans Courts for Veterans Only, whereby you get into the program, you complete the program, they will dismiss the case, and you can get a non-disclosure where your record is sealed to the general public. Only thing you have to do is be a member of any one of the branches or veteran of any one of the branches of the United States military. All right. Now, this court, County Court at Law number 2, has a program that is called the Community Safety Initiative, the CSI program. That's a program that God led me to start within the first 100 days of taking office in March of 2017. That program is designed to address the issue of recidivism. Recidivism simply means that people commit crimes over and over. And so the way we address it is with partnerships. One of the partnerships that we have is with Spindletop. Spindletop is our local mental health authority in the Southeast Texas region. They will, they have the expertise to address any mental health issues that you have. For example, you do not have to be incompetent or insane to participate. You could just merely suffer from anxiety or depression or any other host of mental illnesses, and they will be able to address those issues. Now, with Spindletop, what they will do, they will first conduct an interview, private interview, either in a jury room, at their facility, by telephone, whichever is convenient for you. Then they can do an assessment to diagnose what your problem may be. And then they can develop a treatment plan for either outpatient services or inpatient services. Now, if you have issues with drugs and alcohol, they have a program called ATAR, ATAR, and it stands for Addiction, Treatment, and Recovery. We also have a partnership with our local drug and alcohol council that has a program that's called OSAR, OSAR, that stands for Outreach, Screening, and Referral. Both of those programs are drug and alcohol recovery programs, and what they will do, they will have a screening, assessment, and then they can develop a treatment plan for outpatient or inpatient treatment, depending on what your needs are. If you're unemployed or if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. It stands for Center for Innovation, Commercialization, and Entrepreneurship. It's a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you're trained in any one of those areas, then they will assist you at getting a job in the area that you're trained in. And if you have not graduated from high school, if you do not have a GED, then they have a GED program where you can receive your graduate equivalency diploma. Now, all of those programs, all of these programs that I just mentioned to you are free. Does not cost you anything but time. And I like this quote, we don't just give time, we take out time. That is, we do not just arrest the problem, we address the problem. And if we address the problem, we believe that we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so therefore, I say that when you come to county court at law number 2, we don't have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individual that comes before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. And so if you're interested in any one of these programs, just let us know. We'll be happy to have you talk to the individuals that you need to talk to get into the program. Now, at this time, we're going to have some folks from Spindletop. We have Caitlin and Deputy Barry. They're going to come to you and talk to you a little bit more about the program that Spindletop has to offer. Then we'll have Mr. Cook from Texas Store. Thank you.
Thank you, Your Honor.
You're welcome.
Good morning, ladies and gentlemen. My name is Deputy Barry. I'm the mental health liaison for Jefferson County Sheriff's Office. 20+ years with the Sheriff's Office. 7 of those, almost 8, have been with the mental health division. My partner Caitlin here is a qualified mental health professional with Spindletop Center. We work together as a partnership to bridge the gap between law enforcement and mental health. So the reason that we're here in this courtroom today, as the judge stated, we hear about everybody that enters this courtroom, okay? And we have found statistically that people who enter the criminal justice system oftentimes have mental health needs that are not being met, or substance use issues, or just simply a lack of resources. So that's what we're here for today, is to initiate that contact. If you notice, there was a small piece of paper on the clipboard when you enter this courtroom. Okay, that piece of paper is for Spindletop Center. That is not mandatory that you fill it out. It's not a requirement for the court. Okay, this is a way for us to contact you to provide you with the resources that you need, or maybe resources that somebody else who you know needs. So Ms. Caitlin here is going to explain to you briefly how to fill out that piece of paper, and we'll go from there.
At the top of the piece of paper is basic information. It's your name, your birthday, your phone number, your email. We need those things to put you into our system and to be able to contact you. Underneath that is how you'd like to be contacted, and it's call, text, or email. Whatever you check is how we'll contact you. It's how we'll contact you unless you check one of those boxes. Underneath that is forms. Oh, underneath that is things you need help with, and whatever you check, most of them is forms or a link that I'll email you that you have to fill out yourself. But if you were to check mental health, which could be depression, anxiety, or PTSD, or substance use, which could be any type of drug or alcohol, then we can help you get into Spindletop services, and it can provide you with the support and the resources that you need for those specific topics. If you would like to talk to me in person to get Spindletop services, you can write, please talk to me today on your paper. But if it doesn't matter when I get to you, you can just check one of the contact boxes and I'll call you within the week.
So again, this is absolutely voluntary. You're not required to fill it out. If you want to, if you decline to fill it out, just leave it blank on the clipboard. And whenever we come by and pick up the clipboards, we'll pick that information up as well. If anybody has any questions, we'll be by in a few minutes. If you do not have one and you'd like one, if we missed you, let us know and we'll get that taken care of, okay? Thank you.
Okay, thank you.
Thank you.
Deputy Barry and Ms. Caitlin. At this time, Mr. Cook.
Hello, everybody. Good morning. So I'm gonna be David Cook, I'm with Texas Care. And, we're a little bit different than Spindletop, but I did put a flyer in the clipboard. If you need another one, I have some more people came in. But, so we do like crisis intervention, individual therapy, skills and development training. And, you can take the card and scan it, and it'll take you straight to the website. And, if you can't use it for yourself, if you know anybody else that can, use it, pass it on. We do like targeted case management, telehealth, and our qualified mental health professionals will come to you, or to the school if it's your children. But we work with children ages 3 to 17, and then also adults, and we also do substitute. Yeah, if you have any questions, I'll be here after court, so. Thank you.
Okay.
Can I get one of those? Yeah.
Okay, now, ladies and gentlemen, we get ready to go into recess. We're gonna give you time to fill out the paperwork. Now, if you need any assistance with filling out the paperwork, just let us know. My staff and myself will be happy to assist you with filling out the paperwork. We're gonna ask that you raise your hand and then we'll call you up or they'll come out to you and help. Now, this is gonna now, once you finish filling out the paperwork, we're gonna pick the paperwork up from you. And then we're gonna go through the paperwork and then we're gonna call you one at a time to come up to the bench. And then we're gonna put you into one of 3 categories. Either you wanna hire an attorney, you wanna qualify for court-appointed attorney, or you wanna represent yourself. One of those 3 categories. And then we'll basically take care of your case today. Now, if you apply for a court-appointed attorney and if you qualify, you will be appointed an attorney today, okay, before you leave. All right? And if you are representing yourself, your case will be taken care of today. You'll talk to one of the prosecutors before you leave. And if you agree to a plea bargain agreement, it will be taken care of today. All right? Now, this is gonna take us a few minutes to have you to fill out the paperwork and for us to pick it back up. If you need to use the restroom, there's some restrooms right out in the hall. The men's restroom is in front of County Court at Law Number 3, which is right next door. The women's restroom is on the opposite side of the hall in front of the 172nd District Court. Now, you'll be allowed to go out into the halls, use the restroom. Now, do not leave the courthouse. If you leave the courthouse and we call your name and you're not here, then your bond is gonna be forfeited. You know what that means? You forfeit your bond, a warrant is gonna be issued for your arrest. And guess what? You will get arrested, go to jail, probably have to bond out of jail again. And guess what? We're gonna have to go through this all over again. Okay? And so, just make sure that you don't leave the courthouse, and we're gonna try to get you in and out as fast as we can. Okay, now before we go to break, anybody have any questions? No questions? All right, we're going into break and make sure that you conduct yourself accordingly because we're still in court. Okay? All right.
If you're done with the clipboard, I can pick it up. Make sure at the top of that first page, you put your name where it says
Jefferson County Court at Law number 2 is back in session. The court is in session with the arraignment docket. First case. The first two cases. On cause numbers 25 CCCR 1204 and cause number 25 CCCR 1205. Both cases are styled the state of Texas versus Andrew James Walter. Mr. Walter, would you please come forward? That's right. Mr. Walter, your full name is Andrew James Walter.
Yes,
Mr. Walter, would you please place your right hand? Mr. Walter, do you swear affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
yes,
Mr. Walter, you may put your hand down. How are you doing, Mr. Walter? You doing pretty good? That's good. Mr. Walter, I have before me a document that is titled Judge's Explanation of Right to Defendants Without Attorney. Do you recognize this document?
yeah, yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Or these your initials on the line that state you'd like to have your case reset to hire your own attorney?
Yes, sir.
Now, Mr. Walter, before you signed and initialed this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Mr. Walter, your case is going to be reset to give you an opportunity to hire an attorney. Our court coordinator is going to reset your case. Once she resets your case, you will be free to go. And you have a blessed day. Please have a seat in that first chair on the wall. Walter. Andrew Walter. Huh? He does?
Yeah, I think so. I think I made copies.
Okay. Mr. Walker, would you please come back up? I need to give you some bond conditions.
Yes, sir.
The bailiff is gonna hand you a document that is titled Standard Bond Conditions in County Court at Law number. Mr. Bailiff, could you hand this document to me?
Yes, sir.
It's titled, Standard Bond Conditions in County Court at Law number 2. Do you see that document? Okay, this document states following return of criminal information in County Court at Law number 2 of Jefferson County, Texas. All bail bonds executed release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Condition number 3 does not apply. Condition number 4 does not apply. However, on the next page, condition number 5 does apply, and the state's defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. You understand that condition?
Yes, sir.
Now, Mr. Walter, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant can be issued for your arrest, and the warrant will be issued for arrest, you'll be arrested and placed in Jefferson County Jail. Mr. Walter, just have a seat in that chair. Wait for your name to be called. Once your name is called, you're free to go and you have a blessed day.
I'm ready for you.
Jeremy Allen Broussard. Please come forward. Okay, Mr. Broussard, your full name is Jeremy Allen Broussard.
Yes, sir.
Mr. Broussard, would you please raise your right hand? Give me some bond condition. Never mind. Hold on a minute, Mr. Broussard. You have time to fill this out. Um, Make a copy. Okay, Mr. Broussard, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing, Mr. Broussard? That's good. Mr. Broussard, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Or these your initials on the line that state you'd like to have your case reset to hire your attorney?
Yes, sir.
Now, Mr. Broussard, before you sign and initial this document, did you read the document?
Yes, sir.
Did you understand what you read? Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Thank you. Okay, Mr. Broussard, I'm going to give you some bond conditions. Document is titled Standard Bond Conditions in County Code Law Number 2, and it states, following return of criminal information in County Code Law Number 2, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir. Condition
Number 2, defendant shall submit to, let's see which one is. Defendant, no, number 2, the defendant shall submit to testing of drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, he didn't date it. You can hand those bond conditions back to me. Here you go. Okay, now condition number 2 states that the defendant shall submit to test for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. You understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? Now, condition number 4 does not apply. Now, Mr. Broussard, if you violate any one of these conditions, your bond will be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. You understand?
Yes.
Okay, now have a seat in that first chair, wait for your name to be called. Once your name is called, go to the window where your name is called. And once you finish up the window, you're free to go and you're blessed day.
Judge, he is a pending felony that's set on July 17th.
You're gonna set it on the same day? Okay,
But when you come, let me check in. Okay. Oh, we were doing it, but we don't have a document today. We'll be here. Go to your family, come to the and then so we have to educate.
Door is locked.
that door is locked. Yes. Gordon Clark Joseph Sandifer There you go. Yeah, hold on, man. You should have that. You should. Yes, does he have one case or two? Just one? Okay, well. Okay, Mr. Sanford. Your full name is
Jordan.
Jordan.
Yes,
Okay, Jordan Clark Joseph Sanford. How are you doing, Mr. Sanford? That's good, Mr. Sanford. Would you please raise your right hand? Sanford, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Sanford, you may put your hand down. How are you doing, Mr. Sanford?
You doing?
You doing okay?
Yes, sir.
Okay, Mr. Sanford, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you would like to have your case reset to hire your own attorney?
Yes, sir.
Now, before you sign this document, did you read the document?
Yes, sir.
Did you understand what you read?
Mhm.
Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Sanford, your case will be reset. Give you an opportunity to hire an attorney, but before we give you the reset, the bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that document?
Yes, sir.
And it states following return of criminal information in County Court at Law Number. This one don't apply. Let me see that. Hold on back. I need to strike through. this thing. Okay. Get us back to. Okay, now Mr. Sanford, this document is titled Standard Bond Conditions in County Court at Law Number 2, and it states following return of criminal information in County Court at Law Number 2, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number one, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
And condition number 2, the defendant shall submit to testing for drugs and alcohol anytime as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so, and B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? Okay, do you understand that condition?
Yes, sir.
Okay, and condition number 3 and 4 and 5 does not apply. Okay, now if you violate any one of these conditions, your bond will be revoked. You'll be arrested and placed in the Jefferson County Jail. When you have a seat, wait for your name to be called. Once your name is called, okay, you'll be free to go. Destin Gillinger. Mr. Gillinger, your full name is Destin Gillinger?
Yes, sir.
Mr. Gillinger, would you please raise your right hand? Mr. Gillinger, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Gillinger, you may put your hand down. How are you doing, Mr. Gillinger?
Doing all right.
Okay, that's good, Mr. Gillinger. The state is represented in this case by Attorney Sharon Hilton. Mr. Hilton, how are you doing?
I'm good, Your Honor. Thank you.
That's good. Now, Mr. Gillinger, I have before me. Mr. Gillinger, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line as titled defendant?
Yes, sir.
And are these your initials on the line that state you like to waive your right to attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial.
Yes, sir.
Do you recognize this document? And is this your signature on the line as titled defendant?
Yes, sir.
Mr. Gillinger, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
And state, you have
Yes, Your Honor.
passed it off, you given an
Mr.
answer to Mr. Gillinger?
We have, Mr. Gillender's in the Navy. He said that he's going to pay the restitution today. And if he does so, the state then agrees to dismiss. So I guess we would just ask the court for a resetting for 1 week, just to keep it on the docket. But he's told me that he can make sure that that payment is done today.
Okay, now, Mr. Gillinger, your case will be reset to 1 week, for 1 week, and that's, is that July 8th?
Yes, sir.
8 at 9 AM. Now, if you pay the restitution, apparently you'll go to the district attorney's office with the payment. And if it's correct, then the district attorney is going to dismiss the case and you will not have to come to court
Yes, sir.
on the 8th of July.
Yes, sir.
Okay?
Yes, sir.
All right. So your case is reset to July 8 at 9 AM. You can get your reset. Once you get your reset, you'll be free to go. Did you give him the information as to how he's gonna pay it?
I was about to go.
Okay.
With him.
Here you go. Oh,
They're expecting. Yeah, I'll go.
Brandon Elliott. Mr. Elliott, your full name is Brandon Elliott?
Yes.
Mr. Elliott, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Mr. Elliott, you may put your hand down. How are you doing, Mr. Elliott? I'm doing fine, thanks for asking. Mr. Elliott, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you like to apply for court-appointed attorney? I also have another document that's titled Jefferson County Affidavit of Interviews. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there is a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
Now, Mr. Elliott, before you signed and initialed these documents, did you read the documents?
Yes.
Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Mr. Elliott, I read your answers. Based on your answers, you meet the eligibility requirement for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Mark Faggart. Attorney Faggart will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you the information, you'll be free to go, and you have a blessed day. Please have a seat in that chair and wait for your name to be called. Alicia Spriggins. You could come down right there. Miss Spriggins, your full name is Alicia Rose Spriggins?
Rosa.
Rosa Spriggins? Miss Spriggins, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Miss Spriggins, you may put your hand down. How are you doing, Miss Spriggins?
I'm well.
That's good. Now, Miss Spriggins, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
I do.
And is this your signature? You didn't sign it. Miss Bailiff.
Yeah.
Okay, now, Ms. Spriggins, I have before me a document that's titled Judge's Explanation of Rights of Defendants Without Attorney. Recognize this document?
I do.
And is this your signature on the line that's titled Defendant?
It is.
Or these your initials on the line that state you like to apply for court-appointed attorney? I also have another document that is titled Judge's Explanation, that's titled Jefferson County Affidavit of Indigence. Do you recognize this document?
I do.
On page 2 of this same document, there's a signature above the line that's titled Defendant Signature. Is this your signature? Now, Ms. Spriggins, before you signed and initialed these documents, did you read the document?
I did.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Spriggins, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney David Grove. Attorney Grove will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get that information from the court coordinator, you'll be free to go. And you have a blessed day. Please have a seat in that first chair on the wall.
Thank
You're welcome. Jaquan Broussard. Mr. Broussard, your full name is Jaquan Broussard? How are you doing, Mr. Broussard? That's good. Now, Mr. Broussard, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Mr. Broussard, you may put your hand down. Mr. Broussard, I have before me two documents. The first document is titled Judge's Explanation of Rights of Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you'd like to apply for a court-appointed
Yes,
attorney? I also have another document that's titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Mr. Broussard, before you sign and initial these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes,
to the
sir.
best of your knowledge? Mr. Broussard, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Jack Lawrence. Attorney Lawrence will be given information to contact you, and you will be given information to contact him.
Yes, sir.
Our court coordinator will give you that information. Once she gives you the information, you'll be free to go. And you have a blessed day. Please have a seat
Yes,
in
sir.
that second chair on the wall. Thank
Yes,
you.
sir.
Dale Searle. Mr. Searle, you have two cases, cause numbers 25 CCCR 1102, cause number 25 CCCR 1106. Both cases are styled the state of Texas versus Dale Christopher Searle. Mr. Searle, is that your full name?
Yes, sir.
Searle, would you please raise your right hand? Mr. Searle, do you swear affirm, tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Searle, you may put your hand down. How are you doing, Mr. Searle?
Mark.
That's good. Mr. Searle, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that's titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Mr. Searle, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Searle, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in these cases is Attorney Todd LeBlanc. Attorney LeBlanc will be given information to contact you. You will be given information to contact him. Our court coordinator will give you that information, but before she gives you that information, the bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see the title on that document?
Yes, sir.
Okay, I'm going to go over these bond conditions with you. And it states, following the return of criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Now, condition number 3 states the defendant shall not communicate either directly or indirectly with the alleged victim. In this case, well, you have 2 victims. You got a victim in each case. With the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
And condition number 4 doesn't apply. That only applies in the DWI case. Your case is not a DWI case. Condition number 5 does apply, and it states that defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes.
Now, Mr. Searle, if you violate any one of these conditions, your bond will be revoked. And if your bond is revoked, you'll be arrested, placed in the Jefferson County Jail. Do you understand?
Yes, sir.
Okay, now, Mr. Searle, please have a seat in that first chair on the wall and wait for your name to be called.
Thank you.
All right. It's Kareem Johnson. Mr. Johnson, your full name, is it Kareem Abdul Johnson?
Mhm.
Mr. Johnson, would you please raise your right hand? Mr. Johnson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Uh-huh.
I do.
Okay, Mr. Johnson, you may put your hand down. How are you doing, Mr. Johnson? I'm doing fine, thanks for asking. Now, Mr. Johnson, I have 4 cases. First case is cause number 25 CCCR 1086. Second case is cause number 25 CCCR 0636. Third case is cause number 24 CCCR 1440. And the fourth case is cause number 24 CCCR 1442. Hold on a minute. Yeah, I got off. Now you got 3 cases. That last case wasn't yours. Okay, well, I got them out of order. Let me do it again. It's cause number 25 CCCR 1054. Cause number 25 CCCR 1085. Cause number 25 CCCR 1086. And cause number 25 CCCR 0636. All 3 cases are styled Kareem Abdul Johnson. Now, Mr. Johnson, I did 4. Second time. Now, Mr. Johnson, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Sir.
Is this your signature on the line as titled
Yes, sir.
defendant? And are these your initials on the line state you'd like to apply for court appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence, you recognize this document?
Yes, sir.
Now, on page 2 of the same document, there's a signature above the line that is titled Defender Signature. Is this your signature?
Yes, sir.
Now, Mr. Johnson, before you sign and initial these documents, did you read the documents? Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best you know? Now, Mr. Johnson, I read your answers. Based on your answers, you do not meet the eligibility requirements for the appointment of a court-appointed attorney. Now, you have two other options. You can either ask that your case be reset to give you time to hire an attorney, or two, you can waive your right to an attorney and represent yourself. Okay, so I'll let you give him this. You can have a seat. You can go back over this document. You can make your choice, and then we'll call you back up.
Okay.
Damon Jackson. I need some button. Let me see. This is cause number 24CCCR 2250. Case is styled the state of Texas versus Damon Deshaun Jackson. Mr. Jackson, is that your full name?
Yes, sir.
Mr. Jackson, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Jackson, you may put your hand down. How are you doing, Mr. Jackson? I'm doing fine, thanks for asking. Mr. Jackson, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. And the second document, I'll try to get to that later. Now, Mr. Jackson, do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes.
Now, Mr. Jackson, I also have before me a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And on page 2 of the same document, there's a signature above the line that's titled Defender Signature. Is this your signature?
Yes.
Now, Mr. Jackson, before you sign and initial this document, did you read the document? Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Jackson, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney John Macy. Attorney Macy will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. But before she gives you that information, I need to give you some bond conditions. Would you, you have it right here? Oh, did you? Okay. Please hand these bond conditions to Mr. Jackson. Now, Mr. Jackson, the document is titled Standard Bond Conditions in County Court at Law Number 2. And it states following return of accruing information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds are executed for release of any defendant named herein or ordered subject to the additional condition. Number 1, defendant shall commit no offense against the laws of this state, any other state, or against the United States. Do you understand that condition?
Yes, sir.
Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3 and 4 does not apply. However, condition number 5 does apply. Condition number 5 states that the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer, as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that?
Yes, sir.
Okay, now, Mr. Jackson, if you violate any one of these conditions, your bond will be revoked, and if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Mr. Jackson, please have a seat in that first chair on the wall. Wait for your name to be called. Once your name is called, you go to the window. Go to the window, you'll be free to go, and you have a blessed day.
Thank you.
Okay. Christopher Jones, is that the guy in the back? What's that? Okay. Chris, I don't have the paperwork, but I had a paperwork on that gentleman back there. Did y'all talk to that gentleman in the back?
Of course.
Darcy,
We talked to him, John.
y'all still have his paperwork?
I brought it up to them.
Okay, I thought it was in the back.
Oh,
it's
that's who's in the back.
it's in the back. Okay, I got it. Okay, Mr. Darcy, please come forward. Okay, Mr. Darcy, let's see. Your full name is Edwin Johns Darcy? Oh, I got an S on the end. Okay, I don't know what I got it. Okay, now, Mr. Darcy, would you please raise your right hand? Mr. Darcy, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Darcy, you may put your hand down. How are you doing, Mr. Darcy? Okay, now, Mr. Darcy, you have, give me some bond condition. Let me see, you have 2 cases. I'm gonna let you fill this out. Okay, now, Mr. Darcy, you have 2 cases. Now, did I swear you in?
Yep.
Okay, Mr. Darcy, I have 2 cases. Cause numbers 25 CCCR 0550 and cause number 25 CCCR 0551. Both cases are styled the state of Texas versus Edwin John Darcy. Mr. Darcy, is that your full name? You said Edwin John Darcy. Okay. Now, Mr. Darcy, how are you doing? Mr. Darcy, I have 2 documents before me. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
Is this your signature on the line as titled defendant?
Yeah.
And all these initials on the line that state you would like to waive your right to an attorney and represent yourself. I also have another document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. Do you recognize this document?
Yes.
And is this your signature on the line as titled defendant?
Yeah.
Now, Mr. Darcy, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge? Okay. Now, Mr. Darcy, I need to give you what is called a Faretta warning. Mr. Darcy, I need to ask you some questions. Have you ever studied law?
A little bit.
Okay, now, okay, you
Not
waive,
in school.
Okay, so you waiving your right to attorney, you want to represent yourself, okay. So you say you studied a little bit of law?
Yes.
Okay, have you ever represented yourself in a criminal action?
No.
No. Do you understand the charges against you?
Yes.
You do. Now, are you aware of the punishment range of these charges?
Yes, sir.
Okay. Now, do you realize that if you represent yourself, you are on your own as a judge? I can't tell you how you should try your case or even give you any advice concerning your case. I cannot help you in any way. Do you understand that? Are you familiar with the Texas rules of evidence and Texas case law?
Yes.
Okay. Do you realize that the Texas rules of evidence and Texas case law govern what evidence is admitted? And in representing yourself, you must abide by those rules.
Yes.
Now, for example, do you know how to conduct a voir dire?
No.
Okay. Do you know what are the grounds for excusing a juror for cause?
No.
Do you know what is hearsay?
Yes.
And do you know what are some of the exceptions for hearsay?
In a sense, maybe yes. But
Do you know what are the proper grounds for impeaching a witness?
No.
Do you know when character evidence is allowed in trial? Do you know when and how to make proper objections?
No.
Do you know when and how to move for a directed verdict?
I'll pay for it.
Mhm.
I'll just pay, get my own.
Okay, so you wanna change your
Yeah.
mind? Okay. Could you hand that document to him and
Yeah,
you're
sure.
gonna have to scratch through the bottom portion and place your initials on the top line, the first line, it says.
And that's if you've already hired them. Maybe this person.
Okay, now, change your mind. You have your initials on the first line. Is that correct? That states you want to hire an attorney. Is that correct? Okay, so your case, let's see, Mr. Darcy, do we have some bond conditions here? Okay, Mr. Darcy, your case is going to be reset to give you an opportunity to hire an attorney. I need this, the prosecutor is going to hand you a document that's titled Status, Bond Conditions in County Court at Law Number 2. I'm going to go over this document with you, so it didn't put the date on effective. Let me see. Let me see that back. Yeah, effective as of July 1st. Okay, the first document, now this document is titled Standard Bond Conditions in County Court at Law Number 2. Following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. You understand that condition?
Yeah.
And condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 states defendant is prohibited from possessing a firearm ammunition unless defendant is a peace officer as defined by section 1.07 Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yeah.
Okay, now, Mr. Darcy, if you violate any one of these conditions, your bond will be revoked. Once your bond is revoked, you'll be arrested and placed in Jefferson County Jail. Do you understand that?
Yeah.
Now, there's another matter. I see you have a young lady with you.
Yes,
Who is that?
that's my fiance.
Okay, I think I might know her. I'm not sure. Ma'am, what's your name? What's your last name? Brooks? Is that your maiden name? Brian? Okay, I thought you might have been somebody else.
Nope.
She's not, ma'am, she looks like,
Even from there.
oh, she's not from here? Okay, well, that's not, that can't be her then, if she's not from here. Okay. Well, you have a twin that's here. Okay. All right, so, Mr. Darcy, your case is gonna be reset. Once you get your case reset, you're free to go, and you have a blessed day. Okay. They dismissed it? Okay. Okay, last person we have is Mr. Jones. Do you?
Judge, I can speak to you after you're finished.
Okay,
Oh, and, this gentleman right here, he had wanted to approach again.
which one?
Oh, no, he was in the back. He's never approached.
Yeah,
Oh, right.
No.
Oh, he left?
No,
Okay,
I
he
answered his
had-
question.
he wanted to say
I answered his question.
something. Okay, cool.
okay, Mr. Jones,
No,
would you please come forward? Christopher Jones?
yeah.
I need to, let's see, Mr. Jones. Your full name is Christopher Jones?
Christopher Sean Keith Jones.
Christopher Sean Keith Jones.
Yes.
How you doing, Mr. Jones? Okay, Mr. Jones, would you please raise your right hand? Mr. Jones, do you swear affirm to tell the truth, the whole truth, and nothing but the truth so help you God? Mr. Jones, you may put your hand down. Again, Mr. Jones, how are you doing?
All right.
That's good. Now, Mr. Jones, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Maybe some problems on there. Let me see my thing. There we go. And do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, sir.
Mr. Jones, I also have another document, and this other document is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes, sir.
Now, Mr. Jones, before you signed and initialed these documents that I just showed you, did you read the documents?
I really didn't read it. I just was kind of silent.
Oh, okay. Yeah.
Not gonna lie to you.
Okay. Now, let me do this. See, I'm gonna put it on mute. Mr. Jones, is everything true and correct on these documents?
Yes, sir.
Okay, now, Mr. Jones, I read your answers. You meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Jennifer DeLodge. Ms. DeLodge will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Now, before she gives you that information, I think I'm going to give you some bond conditions. And let me do this here. Okay, now, Mr. Jones, let me do this here. Umbrella. I'm looking for a document. Did you get this here? I'm looking for the bond conditions that just have some lines. Okay, here's kind of like that. I need to write some conditions on here. Here we go, this one, okay. Make some copies of that. Now, Mr. Jones, I'm gonna give you some bond conditions. I see we have a animal cruelty case. And so on these bond conditions, it's gonna state as follows: following return of criminal information. In County Code of Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or against the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and a test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Now, number 3 and 4 does not apply. I'm gonna write in number 5. And in this case, you cannot have, own or possess any dogs. Okay? Okay, you got this animal cruelty case. Okay? And so at this time, the court is going to make that an order. Now, if you violate this order, your bond can be revoked. Okay, but I mean, you got this animal cruelty case, and so during the pendency of this animal cruelty case, you cannot own or possess any dogs. You're gonna have to maybe have somebody else to take care of them or whatever, but you cannot be around these animals. Okay.
Okay. That was like my anxiety.
Okay. Now, do you understand these bond conditions?
Yes, sir.
Now, if you violate any one of these bond conditions, your bond is gonna be revoked and you'll be arrested and placed in the Jefferson County Jail. Okay.
And how long is that stays on?
As long, until this case is resolved. You're on bond, you bond, you have, as long as the case is pending, you're out on bond. And as long as you're out on bond, you have bond conditions. Once the case is resolved, you'll no longer be on bond. Okay, do you understand that?
Yes, sir.
Here you go. You'll get a copy and when your case is reset, you'll be free to go and you have a blessed day.
Yes, sir.
Okay?
Just have a seat with your tongue.
With, he needs to come back up for something?
He didn't finish.
Oh, okay, so I see he wants to, have his case reset to higher?
Yes, sir.
Okay, so your case is going to be, reset to give you a chance to hire your attorney. Okay, so just have a seat. Hold on, you got any bond condition on here? Hold on a minute. I don't think so, Johnson. No. Okay, just have a seat in the first chair on the wall. Okay, we'll be in recess. Jefferson County Court at Law number 2 is back in session. The court is in session and calls number 25 CCCR 0464. Case is style of State of Texas versus Amber Renee Brown. Amber Brown was scheduled to be in court this morning at 9 a.m. At or about 9 a.m., the court's bailiff called the name of Amber Brown at the courthouse door. Amber Brown did not answer. Amber Brown has not appeared since the court has been in session. The time now is 12:13 p.m. on today's date, July 1st of 2025. Ms. Bailiff, would you please call the name of Amber Brown at the courthouse door?
Amber Brown,
Yes.
Amber Brown, Amber Brown. North by John.
Okay, Amber Brown name was just called again at the courthouse door. Amber Brown did not answer. A reasonable time has passed to give Ms. Brown an opportunity to appear in court. She has not appeared in court. State, do you have a motion? That motion will be granted. Amber Brown will be forfeited and a warrant shall be issued for her arrest. And this will conclude the calling of the court's arraignment docket on today's date, July 1st, 2025, in County Court at Law number 2 of Jefferson County, Texas. Judge Terrence Holmes presiding. Everyone, please have a blessed day. Prosecutors, you are excused.